Good afternoon, everybody, and I welcome the opportunity to do ethics on a rainy afternoon. Let me give you some thoughts on this. We all want to be good lawyers. We want to represent our clients zealously. We want to do the right thing. But we as lawyers are in this profession because we like to win. We like to win for our clients. We like to win for ourselves. It makes us feel good. And at times when we get that way to feel good, we forget about that our reputation is on the line and we cross the line. And I think about that a lot now. I used to have black hair and now my hair is graying. And what I get worried about is not that I'm going to do something intentionally bad, but as I get to the autumn of my career and the gray hair, I'm going to screw up and I'm going to ruin my reputation. I'm going to make a mistake that I should know better. What do you say when you're a lawyer for 30 years and you make an ethical mistake? It's kind of embarrassing, but it happens to all of us. So we're going to talk about errors of judgment because a lot of times none of us here are going to do the intentional bad act. Maybe some exceptions, but it's usually an error in judgment that we make at the time we're under the heat of battle in litigation, or we're in a tense situation. We make errors of judgment. And I'm going to talk about some simple things. And you're going to say, I know all about that already. I'm familiar with that. I've heard about that already. So I wanted to come up with 10 top ethical mistakes. And they're all pretty common ones. So when you say to yourself, I know about that, and I'm not going to do it, I found plenty of lawyers that have been doing the exact same things that we're doing today. And they're good lawyers like us, they're good people like us, but they're making the same mistakes over again. First mistake, it was talked a little about in our presentation, is who is our client? Who is our client? It sounds kind of simple. We know who our client is. We're in-house, it's a large organization. The organization, not the individual, is your client. Kind of simplistic thing. But let me give you a live, new, recent scenario. You've been in a company for a long time, and you know Senior Executive Y. For 20 years, you trust Senior Executive Y, and you know him well. All of a sudden, you get a call from the U.S. Attorney that they want to talk to employee Y. Why do they want to talk to him? It's involving a money laundering plan in South America. Not your buddy. Your buddy would never do this. So you call your friend in and you say to him, you know, what's the story? He says, you won't believe it. I was in South America doing business and someone stole my identity. And it's not me that they're involved with. No worries about it. Deal with it. And what do? I say 9 out of 10 of you say, okay, thank you very much. I trust you. Well, in this particular case, Mr. Y was having some problems with a little mistress on the side. He needed a little money, a little problems, and guess what? It was true. So you just sat down with him, got his whole story thinking that you're representing him, putting the company at risk, and he was the money launderer. What does that look like for you? How do you feel about that afterwards, after you tell him to go to the U.S. Attorney's office and lie and go under subpoena? How does that feel? And that's one of the problems you have. Sounds simplistic, but that attorney that time was sitting down, thinking, not thinking about it. He knew this person, it couldn't be true. They made a mistake, an error of judgment. And that scares me because there's a lot of other situations. Failure to recognize conflicts of interest. Oh, we all know failures to recognize conflicts of interest. We understand that. We go it doesn't happen to us. But what happens if you're at a company and you hire someone from another firm, a law firm, you're in-house, you hire someone, and then you have all these meetings together about your big-time litigation. And then you didn't do your due diligence, and you find out that you had your outside counsel there too. You find out that this lawyer worked on the same exact case in which you're the plaintiff and he was representing the defendant. You have now disqualified the law firm that you're working with, and you've disqualified everyone in-house. How does that happen? That happens because, well, I hired so-and-so. It happens in law firms too. Someone else does the due diligence. No one ever asked whether that person and what they worked on in the other firm. And they were actively involved, and they participated in the strategy meetings. That's another conflict of interest. Another simplistic thing, there's an incident at the office for your company, a slip and fall case. An employee comes forward and says, I saw it all to the investigator, I know it all, it wasn't the company's fault, I'm your hero, that person feigned that fall, nothing happened there. And you say, okay, we're gonna save some money here, or we're gonna get a lawyer, and we'll do it on the cheap, and we'll go to the deposition, I'll go with you. On the way to the deposition, this is a true story, the employee says, hey, by the way, I didn't really see this. I wanted to be a star, I really didn't see this. You as a good lawyer say to yourself, okay, I'm gonna prevent this, I'm not gonna let him lie. Mr. Employee, just tell the truth and everything will be okay. Just tell the truth. Employee goes in, tells the truth, I saw nothing, I gave it to the investigator as a report, I didn't see anything, I lied to the investigator. You think you've done your job. Well, you get back to the company, and guess who gets fired? The lying employee. And guess what the lying employee does? He sues you for malpractice because you told him everything would be okay, just tell the truth. You gave him improper advice. Now, when you walk into the deposition, do you think you really thought about that aspect of getting sued for malpractice? No, you didn't. And these are mistakes that we all make that we don't think about at times because we're under the pressure, get things done quickly, think quickly. How many of you respond to your clients by email immediately? And if you don't respond at Sunday at 11 o'clock, they want to know why you haven't responded. How much reflection do you give sometimes when you respond to emails like that? Do you think about who the client is? Do you think who the conflict is? And these are good lawyers that are doing that. Waiving the privilege, a nightmare for all of us. We waive privilege all the time. And a lot of people in the bar are not so kind to say, claw it back. You waive the privilege. Why? I produced something to you improperly. You try to claw it back, they don't. They tell you you waive the privilege. How do you waive the privilege? You waive the privilege in a lot of simple ways. You CC someone on a privileged document that shouldn't be there. Let's blame the client. Your brilliant client decides to share some of your advice with a third party. You've waived the privilege. You're at the airport and you're really rushed off and you're really tired and you got to get some stuff done. So you're excited, so you're on the phone with one of your colleagues and spewing your guts, and somebody overhears you at the airport. Or we all used to be careful with our documents. Got our laptop out. We're in the club at the airport. The laptop's out, you go to the bathroom, it's got confidential information, someone just happens to be at the wrong place at the wrong time, and they read it. What have you done? You've waived privilege. I know this is kind of a practical aspect, but if you look at the Martha Stewart case, what did Martha Stewart do? Attorney-client privilege stuff? She forwarded it to her daughter. Why not? Ask for some advice. Deemed that she had waived the privilege. Failure to investigate. If you think that as lawyers, we are the gatekeepers, and you can look at Sarbanes-Oxley and get tired, we are the gatekeepers for what our clients do, and we are the rats to rat out our clients. But when do you have to say something about what your client has done wrong? Well, if lawyers think they can escape liability and by a result of keeping their mouths shut, it doesn't work. You may lose your job for reporting something inappropriately. You may feel uncomfortable, but you are the gatekeeper for all the knowledge. And if you look at some of these cases of the FDIC recently and the SEC cases, you can't close your eyes. And I saw this quote, "A lawyer no more than others can escape liability for fraud by closing his or her eyes to what he saw and could readily understand." Vague enough to make you squirm? Think about how that must be if you're in-house or you're outside counsel and you're going to decide that, I think I'm going to have to protect myself. I think I'm going to report some incident. Sounds good, doesn't it? You'll do the noble thing, but think of the economics of it for you. Think of it, you're 60 years old, 2 kids in college, mortgage payments, and all of a sudden you're going to start ratting out the client. Think about that. And ratting out may not be the right word, but also frauds and improper conduct, it's never black and white. It's always gray. So that's another thing that I see that people do, and I watch good lawyers get in trouble for. Puffery, We have a duty of candor. We have to be honest. We cannot make any false statements to third parties. We just can't. But what's the line? Let's think of some practical aspects of this. I practice here in New York. If you ever have a case in New York, the judge will call you in and say, let's talk about settlement. Mr. Ortego, tell me, I know you for years. What's your authority? What's your authority? And my authority is $100, but if you say $100, the judge is going to say, I think the case should settle for $150. Go call your client and say, I recommend it. So she tells you to do that, and you do it. So what are you supposed to do? Can you lie to a judge, a magistrate, about what your settlement authority is? The answer is no. You cannot lie to the judge. What you have to tell the judge is, I can't tell you. And that's your ethical obligation, and that's really going to get you far, because in New York State, guess who tries our cases? The same person that's negotiating the settlement. You're really going to go far with that. But you cannot reveal. Also, you can't lie to your adversary about insurance coverage. There's a case out there that I read that I found very interesting, in which the lawyer lied about how much coverage they had. The case was settled. A similar case came down, and guess what? He lied about the coverage. Not only did the lawyer commit an ethical violation, the lawyer got sued, and the plaintiff prevailed for the false misrepresentation to a third party, as it should be. And then we get to the fine line of how much is puffery, how much is deceptive? Do you have to give up the bad facts? Of course not. You don't have to tell people what your bad facts are. You can say, I have a wonderful case, but you can't deceive the other side by manipulating false facts. And you really have to shut up, otherwise you're in trouble. There's a fine line between puffery and lying. And remember, we are lawyers. Despite our reputations that sometimes that aren't so kind, we have a duty, and we cannot lie, we cannot manipulate, and we can't lie by omission either. We either have to be quiet or speak the truth. And sometimes speaking the truth is difficult. And when we're in that moment, everyone thinks their case is wonderful. You can say that, but you can't lie about any of the facts. A dishonest client handling it with grace. Big client of the firm, your outside counsel, it's your CEO. And guess what? Your CEO decides to lie, not tell the truth. And they're at their deposition, and you know they're not telling the truth. You're in a trial, you know they're lying. A good career move for the in-house lawyer and the outside lawyer is, by the way, you can't lie. Well, I'm doing what I'm doing, I'm not lying. So why don't you go and tell the judge that your client is lying? Good luck. It's a terrible bind. And you have to know, one of the benefits, we have to have actual knowledge of the lie. So maybe we can play the game a little and hide our heads in the sand, and then you can go home and feel guilty and worry about it forever. But there is an alternative for you. It's called the safe harbor provision, where you basically have to get off the case and remove yourself from the case. Good luck with that as well. It's the end, it's difficult. But in the long run, clients come and go, but your reputation does not. Your reputation is like toothpaste. Once it comes out of the tube, it never goes back in, and you can be ruined. And that's why my hair turns gray. Manipulation of the judicial system. Another interesting factor with the manipulation of the judicial system. What can you do? You know, in state court here, we have a lot of unique things. Can I wait and decide and figure out what judge is the best judge for me? Now, in federal court, you have the wheel, so we can't deal with that as much. But in state court, you can start to figure out who's going to get the TRO, who's going to get the preliminary injunction. When you file your complaint, who's going to get it? And you go talk to your friend in the clerk's office, who you gave a nice basket for the holidays, and say, you know, who's going to be on next on call? Can you do that? The answer is yes, you can. And as a matter of fact, what you can do is have somebody camped out in the clerk's office waiting for the right time to file. You can do that. There's nothing wrong with that. But I'll tell you what's wrong with something else is you can't go around and file about 6 complaints around the country and then decide where you want to end up. You can't do that. A lot of lawyers will find 1 or 2 complaints, different places, saying for jurisdictional purposes, that's okay. One lawyer in Michigan decided to file 13 complaints in different state courts in Michigan until he found the court he liked, and that was found to be unethical and improper. So judicial manipulation, to an extent, we do play the game, you can do it, but there are limitations. Lawyer as the business partner. I find this the most exciting because, hey, let's be a partnership. Let's get together. You got an upcoming company, let me get together, let's get together, and we'll all make money together. Let me take a piece of your business. Happened a lot in the tech world. A lot of law firms got rich doing it. The answer is yes, you can do that. It can be done, but your fees have to be reasonable. And good luck. When you get to the situation, is it my interest or the client's interest? And there's case after case after case where the lawyer is the business partner with the client, and it doesn't turn out too well. 9, this is one of my favorites. I have a current pending case, a pretty prominent plaintiff's firm. Got ugly, made a lot of money. Money doesn't make people happy, so they started suing each other. So we have an absolute pleading immunity. You can put whatever you want in a pleading here, and you have immunity from defamation. Great idea. Well, one lawyer decided to file a 200-page complaint against her former partner. And in that complaint, there was a lot of interesting things in there. 100 pictures of mistresses, illegitimate children, bills from prostitutes, unrelated to the lawsuit, but all blasted into the complaint. Very nice to read, you know. On such and such a day, you had met with this prostitute. On such and such a day, you had this illegitimate child. On such and such a day, you bought these drugs. And let me tell you, the lawyer's 5th wife was not too happy about this. And that's what happened there. Now, the question is, there's a motion to dismiss pending on that. How far can you go with that privilege? What can you do? And I like to end up with this, and there's a lot of sites in the materials I gave you with the provisions in the ABA. What would Mama Ortego say? You know, your mother would always tell you the wrong place, the wrong time, who you hang out is what you are. And that's what we are as lawyers. My mother was right. She is 100% right. Don't get stuck in that car with those people. You don't know what they do. Be careful who you stay with. You are what you are. Hey, listen, we are who we hang out with. We are a lawyer first and not a friend to the client. We have to be the lawyer for the client. And we have to think of what Mama would say. You are who you hang out with and you are who you're with. And keep that in mind. And with a little luck, we won't make the same mistakes as these other people, and my hair may turn black. Thank you very much.